Good morning, everybody. Thank you for joining us. We're going to kind of slow roll it here until people make it in from the waiting room. All right, we are happy to have you with us today. Thank you for joining us. I am going to start like I do every week with some Zoom housekeeping tips. So we remind you about this all the time, but we do ask that you stay muted for the duration of the Zoom today. This is just to minimize background noise and make it easier for everybody else to hear. You are welcome to unmute yourself to ask a question if you would like to, but if you could just otherwise stay muted, that would be great. If you're wondering how to mute yourself or unmute yourself or do any of the other stuff, the Zoom toolbar, depending on your device, is probably at the bottom of your screen. And that's where you're going to find your mute and unmute button, as well as the start or stop video button. So if you want us to be able to see you today, feel free to keep your video on. If you need privacy or you're working or whatever else you need to keep the video off, you're welcome to do that as well. The toolbar is also where you will find the chat button, which might actually be flashing right now because I put a message into the chat. The chat is the best way to ask questions during the Q&A. Like I said earlier, you're welcome to unmute yourself if you want to ask a question verbally. But otherwise, the chat is a great way to ask questions or request clarification as we're talking today. And if we don't get to your question that you put in the chat, Chelsea is really good about keeping track of those and adding them to our list of questions for next week. Also, we do typically remind everybody that the chat is, like I said, just for asking questions and not for, duking it out and getting into discussions or arguments of a legal nature. So don't do that in the chat. Y'all are relatively well behaved, so I don't feel like we need to worry about that too much. And the message that I put into the chat refers you to our YouTube channel where you can watch recordings of all of our previous Q&A videos. And it also tells you how you can submit questions between now and next week, which is by sending them via email to info@condolaw.net. I will remind you, as we do every week, that we are here to discuss general information, not to give legal advice. And so that includes sometimes not being able to answer questions that could get submitted to us via email. Sometimes folks send in questions that are very, very specific. Sometimes people send in questions that are completely outside of our practice area. For example, if you send us a landlord-tenant question, we're not going to answer that because we're not landlord-tenant attorneys. But also, if you find yourself giving us, paragraphs of detail or copying and pasting sections of your governing documents for us to answer your question, you're probably asking for legal advice, which means we're going to have a tough time answering that question in the Q&A. We do try whenever we can to at least cover the subject matter generally when we think it's helpful to, a broad cross-section of community. So keep that in mind. And again, submit your questions via email to info@condolaw.net. Some of you may be aware that the legislative session started this week on Monday, and I'm popping into the chat a reminder about that, as well as a link to where you can sign up to receive the Monday morning minute emails from the Legislative Action Committee through Washington State Community Associations Institute. And if you're thinking, I don't need to sign up for that, I signed up for it last year, you are wrong. I did not realize this myself, but we are required to have everybody sign up every year. So your sign up for the Monday morning minute last session did not carry over until this session. And unless you opt in again, you won't get those emails this legislative session. So please follow the link. The Monday morning minute emails are short excerpts or blurbs about what's going on during this legislative session that is relevant to community associations. Occasionally, there will also be a call to action, like asking folks to sign up to, testify in front of a committee or email legislators about a piece of legislation that we think that we really think we need to take action on as a community. But more often than not, they're more informative than they are asking you to take action. So keep that in mind and consider signing up for that Monday morning minute. The other link that I'm going to pop into the chat is something that I think we also shared with you last week, which is the link to the proposed bill for making all communities in Washington State subject to Wakaiowa. And if this is a new subject for you, I'm just briefly going to say that this is a bill that proposes to eventually eliminate the HOA Act, the old Condo Act, and the new Condo Act, and it would leave Wakaiowa as the last man standing, so to speak, as the one and only common interest ownership statute in Washington state. It would take effect over time. It's not something that will happen immediately if the bill does get passed and signed into law. January 2025 or 26, I think, is the effective date. But it's just something to watch. And if you want to read through the proposed bill or through the bill itself, the proposed statute, and if you have feedback, feel free to email those of us that are on the LAC, and you can reach out to us via the wscai.org website. And for those who aren't familiar, WSCAI and the LAC, that's the Washington State chapter of the Community Associations Institute. And it's WSCAI that sponsors the Legislative Action Committee that pays for the lobbyist who advocates for the interest of community associations in Olympia with the support of our Legislative Action Committee. So I'm going to let that be it for the legislative stuff for now. I also want to let everybody know that we're a little light on questions that were submitted in advance. So if you were thinking about asking a question today, but you weren't sure we were going to have time to get to it, if you pop it into the chat, we'll probably have time to cover it before the end of the Q&A. And without further ado, Katie is going to jump in with our first question.
All right. The first question is to clarify a portion of RCW 6490-525, which talks about budgets and special assessments. And instead of reading the whole statute, I'm just going to read the part that people have a question about, which is, unless at a meeting the unit owners of units to which a majority of the votes in the association are allocated or any larger percentage specified in the declaration reject the budget, ... The question is, what does at the meeting mean? So specifically, does at the meeting mean unit owners must be present physically or virtually at the budget ratification meeting, no proxy? So simply put, at a meeting is either virtual or physical, because we have talked in the past about whether a virtual meeting counts as a meeting. It does, but it also includes proxies. Proxies, if they're a valid proxy, are always okay. You don't need to send out proxies prepared by the association in advance of the meeting. Owners can create their own proxies as provided by the statutes, and all the statutes allow for this. There are some requirements, like the proxy has to be a writing. That can be an email, or if you look at the statute, it can also be a fax, but I don't know who is faxing, but it can be an email. It really just needs to identify who the proxy holder is and the person who is giving the proxy, so their name and unit number is enough to identify them. Basically, you need to be able to go back and check that the person actually gave the proxy. It doesn't need to be signed. You don't need a wet signature, nothing like that. Proxies are valid for 11 months unless they're dated with a specific expiration date. So all of that counts towards someone being at a meeting, even if they're not there physically or virtually. That being said, for your budget ratification meetings and your special assessment meetings, the association has to call the meeting. That doesn't mean anyone has to show up. So if no one shows up, but the people are there, or like the board members are there physically or virtually, that meeting happened and the budget would be ratified. Valerie, do you have anything to add to that?
No, I think that that's a great point. And I just want to emphasize something that you already said. The association does not have to provide proxies, but if an owner shows up with a proxy that complies with the statute, you do have to honor it. And that is true whether they show up at a physical meeting with a piece of paper signed by the owner that gave them the proxy, or whether an owner emails the board or manager, however you guys communicate, and says, I am giving my next door neighbor Joe my proxy to vote at the budget ratification meeting. So you have to honor a valid proxy, even if it was not one that was produced by the association. So I think that's just really important to emphasize, because we have had clients come to us many times wanting to reject proxies because they were not they didn't come, they weren't produced by the association, or just an owner showed up with them, and how do we know that people actually executed these proxies? And I think that unless you have evidence to support that a proxy was not given by the person that it's purported to have been given by, you have to honor the proxy. So there's a follow-up question in the chat. Are budget ratification meetings board meetings or membership meetings? Can the budget ratification be an agenda item on a regularly scheduled board meeting, or should the meetings be separated? Budget ratification meetings are not board meetings. They are meetings of the membership to which every owner is invited. It can occur in person, or they can be conducted virtually. And unless you're combining it with your annual meeting or doing other association business at the meeting, you do not have to achieve quorum in order for the ratification meeting to happen. Like Katie said, you could call the meeting and you could literally have 0 owners show up for it. As long as you comply with the notice requirements in the statute, as long as you make all the required disclosures in your budget ratification notice to the ownership, as long as the meeting happens when and how you say it's going to happen, even if nobody shows up, that meeting happened and the budget is ratified. The default is that the budget is ratified. The only way that doesn't happen is, number one, if there's some procedural defect, like you didn't give the right amount of notice or you didn't provide the required disclosures, or number two, more than 50% of the voting power in the community rejects the budget at that ratification meeting. And that goes back to the original question, which means that includes people voting by proxy. Katie, did you want to add anything to that clarification?
I didn't, but there is one more follow-up about proxies, and it's if someone delivers a proxy at a meeting by showing it on their phone without transmission to the association, does that count? So the proxy doesn't need to be from the owner who is giving the proxy, can be delivered to the person they're giving the proxy to. So if they sent an email to, "Hi, Bob, you were my proxy, signed Martha Unit 301, even, as an email, or I don't know, I would say a text message, if you can verify, would be reasonable. It does, and then that person shows it to the association. I would say that's a valid proxy, but we could always review it.
No, I would agree with you, especially because that is and it's an electronic format that can easily be forwarded to the association or printed to create either an electronic record or a paper record. So if the concern is, well, how do I sort of after the fact validate that this proxy actually existed when I never had a copy of it? Just ask them to forward it to you. So the fact that it hasn't yet been forwarded or transmitted to the association does not invalidate the proxy. All right, I am going to move on to the next question. And like I said, for sure, keep popping your questions into the chat and we will add them to the end when we are done with our prepared questions. The next question that we have is this. A while ago, Valerie mentioned something about the possibility of board members being required to undergo fair housing training in the future. Is there any update on this? And can you refer us to a website where we can get updates? So I'm going to just make another plug for that Monday Morning Minute for the email that I put the link into the chat for earlier. Because yes, there is currently a bill that has now been brought back up in front of the legislature. I put the link to the bill in the chat, and it was reintroduced this session, and it proposes to require board members for all common interest communities to be required to complete training regarding federal and state fair housing laws. The requirement proposed would mean that you have to do that training within 60 days of taking office. The trainings can be done virtually or in person, and the board member has to provide a certificate of completion to the community association, or they can, I think, write their own affidavit, essentially swearing to the fact that they completed the training if no certificate was available. The Legislative Action Committee has not yet determined whether and to what extent to support the bill, which was revived this session after it essentially died or didn't pass last session. And one other thing to note is that CAI National is developing a training that will satisfy this statutory requirement if the bill is enacted. and it's not ready or complete yet, but they anticipate that the training that module that they're creating will be available by the time this statutory requirement takes effect, if the bill does pass and get signed into law. So hopefully that answers the question. Like I said, you can follow the link in the chat to the proposed bill about the FHA training requirement. And Sandra said, I don't see the bill link for the required training in the chat. That's the link that I just put in the chat right before your comment, Sandra. So if that doesn't work, okay, there you go. You see it now. Okay, great. There's a follow-up question in the chat, which is, would the management company be responsible for keeping documentation of the board's fair housing training? Any idea on how this will be enforced if it is enacted? Well, just like a management company keeps any record of an association, and a board member certificate of FHA training is a record of the association, and you would have the same obligation to treat that as a record of the association as you would with anything else. There is not information in the bill, at least not that I remember. I haven't read the whole thing with a fine-tooth comb yet because, like I said, the legislative session just started day before yesterday. I'd have to look at it more closely to see what, if any, information it has in it about enforcement mechanisms. So that's a topic we'll have to come back to in a future week, because we'll be talking a lot about the legislative stuff as the session goes on.
All right, and with that, we will move into question 3, which is, are bylaws required to be recorded? If so, what is the best way to move forward with a homeowners association that was created in 2005 in which the bylaws were never recorded? So first, bylaws don't need to be recorded, with an asterisk, unless they're required by the declaration to be recorded, but this is pretty uncommon, probably especially for a 2005 community. But if your bylaws have already been recorded, then you need to record all amendments to the bylaws, or you can record a rescission of the bylaws that says they're no longer recorded. And we really recommend against recording bylaws. It creates a lot more work when you want to amend them going forward, and it's pretty easy to unrecord them. And if you haven't started recording them, then that's good. If your bylaws are unsigned and undated, but they're a document you've been using for a long time, the current board could consider ratifying them and signing and dating them as the date of the ratification. This just helps. I mean, it always helps to have signed and dated bylaws. So if yours are unsigned and undated, you can fix that a lot more easily than recording them and whatnot. Valerie, do you want to add anything to that?
No, the only thing, well, yes, I guess, no, I don't want to add anything. And then I keep talking. I sound like Ken now. Yes, I have something to add. If you have bylaws that are unsigned and undated, or if you don't know if they're recorded, or you've got recorded bylaws, but an amendment wasn't recorded, or whatever, if you're confused about the status of your bylaws, this is a perfect question to submit to your association attorney for them to tell you, are they recorded? Can we record a rescission so we don't have to keep recording all the changes in the future? And when, in the case of an unsigned, undated document, how can we essentially fix this so that we've got a signed, dated document going forward from this point? So those are things you can ask your attorney.
And also, just as a general statement, the only 2 main documents that really should be recorded, and then any amendments to them, are your survey maps and plans and your declaration or your CC&Rs. Everything else, like your rules and regulations, generally do not need to be recorded. So that's just something to keep in mind when you're moving forward and asking your attorney. Okay, next question. Was there a case recently in Washington where an owner sued the individual board members for trying to enforce conditions made by the association's insurance carrier? If so, can an overview and outcome of the case be given? So I couldn't find, we are not aware of anything. And I looked at every case that had association in the name that came out of the appellate courts and the state Supreme Court for 2023 to present, and I really couldn't find anything. But if you have more details, maybe we can find it next time. But instead of just leaving you with we couldn't find anything, we thought we'd address this more generally, which is there are protections for individual board members so that they're not sued individually by owners. There are statutes that require that any claims against the association be brought against the association, not board members individually. And then RCW 6434-344, which can apply to Old Act communities, is where you would look to find that. And we think there are similar statutes for the other communities, the HOA Act and Ukiah. And there also may be provisions in your declaration that there are likely provisions in your declaration that protect board members individually and basically make any action against the association rather than individual board members who are acting in their capacity as a board member. These statutes do not protect against board members who are acting rogue in their own individual capacity.
Yeah.
Valerie, anything you'd like to add?
Yeah, so I think that is a really important distinction that you just made. The protections that exist for individual board members and their personal liability don't extend to, you know, criminal activity or other acts that are, you know, grossly outside of your authority as individual board members. And I will also comment that part of why we recommend to every community that they should be incorporated is because of the protection of the corporate form from individual liability for unit owners and board members. And also the common interest, the nonprofit corporation statutes also contain some protections in them when it comes to personal liability for individual board members. I will add another point of clarification though. One of the things you said, Katie, is that these protections keep owners from suing individual board members. I will say they are intended to protect you from actual liability, but owners sue whoever the heck they want to sue very frequently. And so this is another reason why we think it's important to make sure you are complying with the insurance requirements, both of your governing statute and your governing documents, in particular having insurance like D&O insurance, which is directors and officers liability insurance, can be a protective layer and can, for example, appoint defense counsel to get claims against an individual board member dismissed when those claims are more properly brought against the association. There is a follow-up question in the chat asking whether there's a case where a court ruled against a board when the declaration protected a board. That is such a broad question, and it's not one that we can answer off the top of our heads. So we're not going to be able to cover that in the Q&A. However, I will say this. The WSCAI annual conference is coming up in April, I think. And this is now a 2-day conference that's a combination of what used to be Law Day and made Managers Only Day, I think. And it's happening at the Sheraton in Seattle. And one of the panels that we did last year at Law Day that we are going to propose at least this year at the annual conference is a case law update that basically updates you on all of the cases in the last year or two that affect community associations in Washington state. So if you're interested in sort of generally learning about case law that affects community associations in Washington state, go to WSCAI.org, click on the events tab, sign up to attend the annual conference, and cross your fingers that our proposed presentation gets selected so that we can do that case law update. So that was just a shameless plug for an event that's coming up that I'm actually really excited about. And I will go ahead and with that jump into our next question. We have a disgruntled neighbor who purposely blocked access to a board member's deeded parking spot. Who should handle a response? So I want to start by saying this is really too specific for us to respond to. And we would want and need a lot more facts to comment on what would be reasonable in any given situation, including this one. And I will also offer, just as an overarching issue, that whenever we advise our clients in a situation like this, one of our goals is to recommend action that reduces the animosity or tension within the community. And I could be completely off base on this, so please take this with a grain of salt, but the way this question is worded appears to take the opposite approach, or could be interpreted to take the opposite approach. The one of the unique challenges, I think, of practicing law within community association law is that these disputes that occur between homeowners and associations, disputes happen, and then when the dispute is over, the people who were part of that dispute still have to live together in the same community. They pass each other in the parking lot, or they drive by each other within the community, or they see each other at the cabana or at the annual meeting. And so one of our goals in advising our clients is always to keep in mind, whenever possible, the preservation of a peaceful relationship within the community. Now, obviously, only certain parts of that are within your control, for example, as board members, but it's something that we try to keep in the back of our minds anytime we're advising a community on a question like this. So I think, to the specific question, generally the board is the group that is responsible for and empowered to enforce the governing documents, including the regulation of how people can park within the community. The fact that it's a deeded parking spot may change a little bit the approach here. And we would need to look at your governing documents and see if there's a particular process that you have to follow within your documents for enforcing violations. The affected board member, I would say, should recuse themselves or choose not to participate in the board's discussion of the potential violation, and should also not participate in voting on the outcome, for example, if there's a hearing on the violation. And we think that's true anytime an individual board member's personal interests are affected by the matter at hand. They should just opt out of voting in the board's decision on whatever that issue might be. If there's a deeper issue with the neighbor, which, the question says we have a disgruntled neighbor who purposely blocked access to their spot. So this does not sound like a one-time thing where somebody made a mistake and forgot, or, maybe they just were having a bad day. And if this is an ongoing issue, one thing that you all could consider is whether there is a place for mediation in this relationship to try to get to the root of some of these issues and maybe come to a place of compromise or resolution for those issues. I also think it's important for board members to recognize and remember that their authority comes when they act in concert with the board as a whole. Individually, unless the board has voted to vest a particular piece of authority with an individual board members don't have any extra authority or privileges than any other owner within the community. So I think it's also important to remember not to use your position on the board to create special privileges for yourself or for other board members, and to not be more punitive when a violation occurs with respect to a board member's parking spot, for example, than you would be if the same thing happened in any other person's parking spot. So I think, I think a lot of times what board members want to hear, and I understand this very deeply, is that rules are rules and it's black and white. And, anytime somebody breaks a rule, especially if it's against a board member, that there's an enforcement action to be taken. But we also want to remind you that the board has discretion as to what enforcement action, if any, it takes when there is a violation, including when an owner's blocking a parking spot. So again, I think this is, a really specific situation. We cannot tell you what to do in this scenario. We would have a lot of questions for a client that came to us with this particular, issue. If I got an email with just this question from a client, I would be like, here is my list of questions for you before I can even begin to comment. But hopefully that gives you at least some general information to help process as you deal with these situations. Katie, did you want to add anything to that? Oh, you're muted.
The only thing I'd add is that you can also look at your bylaws for sometimes they require when a board member must recuse themselves. Some newer ones have conflict of interest provisions. And so that just might be a good starting point if you're thinking about that route. All right, next question. RCW 2403A 575, which is the Nonprofit Corporation Act, allows us to have committees of the board. The board can delegate board powers to these committees, but must assign 2 directors to each committee, and decisions can only be made by those directors, i.e., other members of the committee don't get to vote. This statute does not define quorum for meetings of these committees, nor does it require decisions to be unanimous. For these committees of the board, must both directors be present at a committee meeting in order to discuss committee meeting business if no decisions are made? Can a decision be made by only one of the directors when the other is not present? How is a tie to be broken if the two directors disagree on a matter? So first, this question assumes that there are only two voting committee members, but you can have more than two board members on a committee. The statute only requires that there be at least two. So if there are only two committee members, then you need both present at the meeting to take action. You need a majority of the board members on the committee to make a decision. If you only have two, one is not a majority, so you would need both. If you have three, then two of the three can make a decision. So this also means that if one's not present, one can't make a decision, but also that both need to agree. This is all if there's a motion made and then you have a tie vote, the motion fails. So it's not, it defaults to the negative, not the positive. Basically, if there's a tie, you don't go to the winner. It goes to failing. It's a very complicated way of saying it, but basically it fails if you can't agree. You could present the issue to the full board if the committee can't agree on a decision. And remember that committees only have powers that have been delegated to them by the full board. So basically, if you're concerned that you only have two board members and one's not going to show up or you can't agree, either go to the full board or just get another board member to sit on the committee to break the tie. Valerie, do you have anything to add?
Yeah, the only other comment I'll add is to remember that the nonprofit corporation statutes only controls if your common interest statute does not speak to the issue at hand. And so, for example, Wakaiowa has a fairly robust section on committees and voting and all of that stuff. So if you're a Wakaiowa community, you look first to Wakaiowa for guidance on committees, membership of committees, voting, decision-making authority, all of that stuff. And you only then look to the nonprofit statute as a gap filler. So if you are, for example, an HOA that's governed by the HOA Act, which is like 6 pages long and says nothing about anything practically, you're going to be falling back on that nonprofit statute a lot more than a Wakaiowa community, which has a much more robust common interest statute. So just keep that in mind. The nonprofit statutes don't always control.
Yes. And while you're on a roll, there is a follow-up question, which is the RCW minimum of directors are a minimum of 3 positions, required or 3 directors required. And I don't know if you want to follow that up with this one or.
Yeah, I mean, I think, I think I'd like to remind you all what I just said, which is if we're talking about the RCW minimum number of directors that's specified in the nonprofit corporation statute, I would remind you that you also need to look at what your common interest statute says about this, if anything. I also will remind you that your governing documents very often will set a specific number of board members. They will say you have to have a minimum of 3 board members or a minimum of 5. Some will have a range, a minimum of 3, but no more than 5 or 5 to 7, whatever. So look at your governing documents. And I would interpret this as the number of board members you have to have, directors, right? The positions or the officer positions within the board are a different thing. So the way it works in general is that a community elects a certain number of board members / directors. I'm using those 2 terms interchangeably. So let's say you elect 5 board members, and then the board among itself decides who is going to be the president, who is going to be the vice president, who's going to be the treasurer, who's going to be the secretary, etc. Those are the positions or the officer titles within the board. So I think that answers the question, but if you want to, ask for clarification or additional follow-up, feel free to do that. And I think we will, unless you have any other comments, Katie, I'm going to jump into the next question.
Go ahead.
Okay, here we go. If an HOA's bylaws state that the board secretary shall keep the minutes of all the meetings of the board and of the association, What if an HOA or board meeting is held and the secretary is absent or simply doesn't take notes or write meeting minutes? Can another board officer take notes and prepare the meeting minutes? Or can even a non-board member take notes and prepare the official meeting minutes? I think, yes, anybody can take them in. I mean, like, I'm going to say like super short, like practical answer. As long as you have accurate minutes, that's what matters. And as a practical matter, board members often share duties like taking minutes. People go on vacation, people get sick. You can't just like, what are we, paralyzed without minutes if the secretary is homesick? That's just not how things work in the real world. And often also managers take minutes at the request of the board. So I think that in the real world, minutes are taken by a lot of different folks depending on the scenario. And anyone can take minutes at the request of the board. The secretary is typically the person responsible for making sure the minutes are accurate, but then the board as a whole votes on the minutes at the next meeting. And so there are a lot of controls in place regarding the accuracy of the minutes. So if the board requests that somebody takes the minutes and that person takes the minutes and then the secretary reviews them and sends them out to the board as a whole, and then at the next meeting, the board votes to ratify the minutes and confirms that they accurately reflect the actions that were taken at that board meeting, then the minutes are approved and it's fine. You know, there are other nuances here in the question. If the secretary is refusing to prepare the minutes or to take notes, even though they're present at the meeting, that's a different question. So, you know, if you've got other sort of complicating factors here, then I think this might be something where it's worth asking your manager for advice or asking your association attorney for advice. You know, if you have one board member who just keeps missing meetings and they're just, you know, kind of failing in their duty to even participate effectively as a board member, that's a different question. But I think that the question of who takes the minutes, even though the bylaws say the secretary shall, I think the most important thing is that the minutes actually get taken, that they're reviewed by the board, and then the board votes on them to ratify them as being accurate and reflecting the actions taken. That's way more important than the person that wrote down the notes, right? So, Katie, did you have anything you wanted to add to that?
Nope. So the next question is there an RCW governing how long to retain an HOA ballot? The answer is yes. It's 1 year. RCW 6490-49510, which mirrors the language in the other 3 statutes, requires that ballots, proxies, absentee ballots, and other records related to voting by unit owners are kept for 1 year after the election, action, or vote to which they relate. And one additional comment is that ballots and most other records can be kept in digital electronic format, even if they were originally produced as hard copies. Basically, you can scan and save instead of having a bunch of banker boxes. So again, 1 year, keep your ballots. And this was a change adopted as part of the whole records statutes that changed this past year. Yes.
Yep.
Trying
July
to remember
of
if it was 20. I couldn't remember if it was 2022 or 2023.
Nope, it's
Okay.
2023. And if you guys are wanting to see your particular statutes record section, just Google your statute number. So RCW 6438 if you're an HOA Act community, 6432 if you're an old condo act, 6434 if you're a new condo act, and 6490, but we already gave you that statute number. If you just Google that plus records, then it'll take you directly to the subsection of your statute that has the record section in it, because this is new as of 2023.
Yeah. All right. Next question. Can a board require a board member to use a specific email like hoa.secretary@gmail.com? And our initial reaction is no. So the statute, the notice statutes, which I think also changed to allow for email opt-in, but specifically 6434-396 subsection 1, that talks about how owners and board members opt into electronic format as communication. And if they don't opt in, then you can't send email. We've talked about that a lot. But it also specifies that the person who's opting in gets to designate which email they get to receive notices and communication from. And again, that applies to board members too. So you can't say you must use this email to receive notices. If you don't want to send it to their other email address, then your other option is regular mail or personal delivery, because then they will have not opted into email. So you can ask them to use a specific email address, but you cannot require them to. Valerie, do you have anything to add on that?
Nope, I think you covered it. But I will go ahead and jump into the next question. And this is about elections via Zoom or other virtual meeting platforms. And the question is, how do you handle elections via Zoom when ballots are sent out in advance, but nominations also happen from the floor? So I'll start by commenting that we have had clients that have had to redo their entire election because their process did not comply either with their governing documents or with, for example, the vote by mail requirements in their governing statutes. And these are statutes that also changed recently, 2021, I think. So if you go to your governing statute, like I just covered, let's say you're an HOA Act community, and you Google RCW 6438 and voting, it'll take you to the section of your statute that governs how you vote. You can do the same thing with meetings and look up meetings. Nominations from the floor can complicate things when you're trying to vote by mail, because then your ballot, by definition, which you send out before the meeting, right, cannot have all of the candidates if you have actual nominations from the floor. And sometimes you won't know until the meeting if you're going to even have any nominations from the floor. And some documents have very specific requirements. One example is that we've seen documents that say the vote must take place at the meeting. We've also seen documents that specifically require that nominations from the floor be allowed. And so if you still want to be able to vote by mail, you have to allow for the nominations to occur however your documents require. So are we talking about taking nominations by mail? Are we talking about allowing nominations from the floor? And then perhaps what you do is you send the ballot out after the meeting and vote by mail once you've got all the candidates. But again, that wouldn't work for a community that has a requirement that the election take place at the meeting itself. So I think the short answer to this question is you need to be very familiar with your governing documents and any requirements that are in your documents about voting and elections. And then you need to familiarize yourself with the requirements of your statute when it comes to meetings and voting. And if there's any confusion whatsoever about what your process should look like, that's a trigger for you to contact your association attorney so they can walk you through a specific process that is going to comply with both your documents and your governing statute. And the reason that it matters that you get it right is what we say often is people who challenge association actions successfully almost always do so based on a failure of process as opposed to challenging the substance of the action taken. And so you want to make sure that your process is complete and accurate and that it complies with your documents and state law so that you don't find yourself in the position of so many communities before having to redo the election because you got some nitpicky thing in the process wrong. Katie, did you have anything you want to add to that?
I don't.
Okay.
But I know we have a lot of questions in the chat.
We do. We have some questions in the chat. So I'm going to read the first one. I'm just going to take these in order. And Chelsea, if any came to you directly that weren't in the general chat, if you could put them in the general chat or email them to me, that'd be great, or like message them to me. The first one is this: adjacent neighboring group home and multifamily dwelling has dead or dying trees which would have devastating impact on our parking lot and buildings should they fall or lose large branches. Neither owner will admit to owning these trees. If both owners are warned about the danger via certified mail with proper documentation, can we hold one or both of them liable should a disaster occur? does notice / warning / request to correct the hazard negate the act of nature concept? So I'm going to jump in and take a stab at this, Katie, and then you can add any comments that you might like to add.
Okay.
I'm going to start by saying this. The case law on responsibility for trees and branches and stuff is evolving actually a fair bit right now. And I want to remind you all that we don't give legal advice here. So this is not a specific answer to your specific question about this, neighboring property or properties and those specific trees. In general, when a tree falls over or a branch falls down and damages the property upon which it lands, the damaged property owner is the one who has insurance to cover and pay for that damage, essentially. So if I have a neighbor right next door and they have a tree on their property and we have a windstorm and that tree falls down and lands on my house, most of the time, the law finds that I'm the one who's responsible for dealing with that damage. And so I submit a claim to my homeowner's insurance, and my homeowner's insurance policy is the one that pays to repair the damage. There are scenarios in which if a tree is a known hazard and an owner has been put on notice of that known hazard and they fail to mitigate the hazard and handle the situation, that the neighbor could be held liable for it. However, in order for that to occur, not only would you have to put them on notice of the hazardous condition, but then you have to, after the fact, basically sue them to get them to pay, right? And so at the point is, it's only at the end of a successful lawsuit, if you sue them and prevail in court, that they then would have to reimburse you for the damages. I'm not sure whether litigating issues like tree hazards contain an attorney fee provision. I'd have to look at any statutes that are relevant to that. And if you're not guaranteed to get your attorney's fees back after prosecuting a lawsuit like that against your neighbor, sometimes those lawsuits are not very beneficial to you, right? Because if you pay $50,000 to take this thing through the point of a trial or an arbitration or whatever, and then you get an award for $50,000 or $100,000, but you have to offset it by the cost of your attorney's fees, maybe it's not really worth it, depending on the dollar amounts in question. So, to sum it up, check with your association attorney, because this is not legal advice. The case law on tree stuff is rapidly evolving, and most of the time, without other external factors, the responsibility lies with the person upon whose house the tree has fallen. Katie, did you want to add anything to that?
Yeah, the only few things I add are, this is so specific, you really should contact your association attorney about this. And again, not giving legal advice, generally, you can cut roots and branches that are overhanging on your property. So if there's a big branch that's about to fall and it's completely on the association's property, the association can cut that branch or the roots. And I might need to check, but I'm pretty sure even if it will harm the tree, you can cut it. So you don't need to let it do the damage. Now, if you're worried that it'll fall over, that's different. But definitely contact your association attorney.
Yeah. The other thing that I wanted to comment on is, because the question specifically asked about if you gave them notice by certified mail. I know everybody thinks certified mail is better than regular mail. And when you get a return signed card confirming that they actually got the thing, it's great. But I would say 8 times out of 10, when somebody sends something by certified mail, the mail goes unclaimed and then you just get it back, 4, 5, 6 weeks later. So if you're sending notice by certified mail, send it by regular mail too, because a lot of times people are not going to take the extra step that they have to take by signing that green card and taking it to the post office or whatever to actually get the certified mail. Whereas if you send it regular and certified and the regular mail does not get returned to you, at least you have some indication that they received it. No, but that's no guarantee that people actually read their mail, but that's just a general comment that's not specific to the tree issue at all. All right, here's our next question from the chat. In a community where the declaration states that unit parking is only allowed in the driveway and garage of the unit, but has other private street parking available that are not marked as guest parking, How can this be clarified for the community? And can the association rent these spaces out to units? Katie, you want to take a stab at that one, or you want me to jump into it?
Yeah, I can start. So generally the board has the authority to regulate the use of the common elements and limited common elements. But in this case, any parking that is not a limited common element or part of the unit would be common element. And so the board can make decisions on how to regulate if it's guest parking, if honestly, if it can be rented unless there's an exception in the declaration that says otherwise. So there's a lot of discretion that the board has on how to use these spaces. And that's kind of the simple answer. You can just put up signs. The only thing you probably would need to check with someone on based on your governing documents is removing the parking. And that's because when the declaration's recorded, it says how many available parking spaces there are, whether or not they're limited common elements or common elements, and that's submitted to the city, and the city and the planning people have requirements for parking. So if you're trying to take away parking spaces, that's a different question, but regulating who can park there, as long as they're private streets and not public streets, there's a lot of discretion for the board.
Yeah, and the only thing that I would add to that is, and part of the question is, how can this be clarified for the community? I think you have to make it clear to the community. So I think what you need to do is, if you're going to try to limit who can park in which spot, then the spots need to be marked so that people know where can I park, where can I not park. And you should probably have a clear, however, also simple, if possible, set of parking rules that make it really clear who's allowed to park where. Is there a time limit on guest parking? If I have somebody, staying with me for 2 weeks, do they have to move their car every 48 hours, or can they just whatever? Are you going to require people to have a permit to park in the guest spot? So you want to decide. The board gets the discretion to do this. They can solicit feedback from the ownership as they're developing an approach to parking rules. And then you want the rules to be really clear, because you don't want to hide the 8 ball. You don't want to be like, haha, you get fined for parking where you weren't supposed to, when an owner, like, how the heck are they supposed to know if you don't make it clear, right? So I think signage or marking the spots is important. And I think having a clear set of rules is important. Because otherwise your ownership doesn't know how to follow rules that don't exist or that are unclear.
Yeah, and your rules also cannot conflict with state or local ordinances. So if there's a fire hydrant or a fire lane, you can't say that that's guest parking.
Correct. All right, here's our next question from the chat. It often happens that the minutes are taken, they are provided in advance of the next meeting, and they get approved by the full board. Then in a later meeting, a board member wants a change made to those approved minutes. Are we allowed that? Or would the requested correction be noted in the new meeting minutes and a change of the prior approved minutes is not done? So I'll go ahead and get started with this. And the first thing that I'll say is that we've answered this exact question within the last, I want to say, like 6 weeks. So if you want to go to our YouTube channel and search within the channel for minutes, you'll see, and sort by the more recent videos, you'll come across our answer to this question in a recent Q&A video. Once meeting minutes are approved by the board, those meeting minutes don't get changed. If in a subsequent meeting, a board member brings up to the full board, hey, look, I think maybe that was incomplete or inaccurate or whatever, and the board as a whole agrees and votes on that and finds that some sort of clarification needs to happen, then you can vote on that at a subsequent board meeting and then even attach those meeting minutes or a clarification to the minutes that were approved by the board. But you don't go unapprove the minutes or revise minutes that have already been approved by the board. So that's your correct procedure. And this only happens if the board as a whole agrees that the minutes as approved are somehow inaccurate or incomplete. One board member deciding that they're inaccurate or complete is not enough. It has to be voted on by the full board, and then you just attach a clarification to the existing minutes as they were approved. Katie, did you have anything else you wanted to add to that?
The only thing I'd add is that the initial approval of the board meeting minutes don't need unanimous approval by the board. It's just a majority. So if one board member holds out because I don't know, they're upset or something, the meeting minutes are approved the initial time with a majority.
Yes. Okay, I think we've got time for at least one more. If the CC&Rs do not require open meetings, but the board sends an official notification to the owners that there are open monthly meetings, providing a date, time, and location, must the board provide open meetings until a notice is sent to the contrary? And that's a great question. I'm going to start by saying that we are really big fans of open board meetings, and we think that even when they're not required, you should do them pretty much all the time. And I also think there is no statute or case law that specifically speaks to this question. In other words, once you've sent out a notice of open board meetings, can you just stop holding them without notifying your ownership? And my answer to that question would be, why would you do that? If you're going to have open board meetings, have open board meetings. If you decide for whatever reason that you're changing your schedule or you're not going to have open board meetings again, then notify your ownership that you're no longer having open board meetings. As a practical matter, this is a low effort step to take. And I think you are risking a little bit, at least in terms of goodwill within your community, if you just stop holding open board meetings. Like, what are you going to do? Like, tell people they show up for the open board meeting and you're going to be, nope, they're not open anymore, you can't come in? Are you just going to like change the location or the time or the date? Like, I have so many questions about this question.
Yeah.
So even though there may not be a statutory requirement that you have to tell them they're no longer open, I just think as a practical matter, as a business matter, as a sort of good faith and reasonable decision-making matter, you should tell them. But Katie, I have strong opinions. Maybe you're more moderate.
I think especially if you've been having open meetings for a really long time, I think to go to, I guess, closed meetings would, I mean, sometimes courts make decisions based on just a longstanding practice, even though it's not required. But I think it's also important to remember that open meetings do not mean owners get to participate. They get to observe. And I think that's a key distinction of, I mean, I completely understand not wanting a bunch of owners to come in and just complain at the board for 5 hours. So I think there's a balance between letting owners observe and listen versus running the meeting, or even with an open owner forum portion at the end, giving an opportunity to comment, which is required under some of the statutes. That's different than just shutting everyone out.
I agree. And I think actually my additional comment would be speaking to your recent comment that an owner comment period or participation period is required under Wakaiowa. And I also think we would be remiss if we did not remind everybody there's a bill in front of the legislature this session to make Wakaiowa the only governing statute left for community associations. And if that passes, then within a couple of years, every community will be required to hold open board meetings. And that will include the opportunity for owners to comment at each board meeting. So if you aren't already holding open board meetings, I would say read the writing on the wall, because you're probably going to have to start doing that within the next few years. And maybe now is a really good time for you to practice without having to allow for an owner comment period, unless your community is required to do that. And also you can start practicing now for that owner comment period by adopting some reasonable rules around that owner participation component. And one of the most important things that I think any community can do in running efficient board meetings, whether or not they're open, whether or not an owner comment period is required, is have someone with a strong personality run the meeting, so that they are able to shut down tangents. They're able to shut down owners who try to control more time than is reasonable at that meeting. Get that practice in now, because it can be intimidating and kind of uncomfortable to run a meeting and to be the one to say, sir, I'm really sorry, but your time is up. We're going to have to move on to the next issue. So start practicing that now, because I do think that all communities are going to be required to hold open board meetings in the near future. And with that, we are almost at 11 o'clock, so I think we've run out of time. We'll keep the last couple of questions that we didn't get to as kind of starter for next week. Thank you all for joining us, and we'll see you back here next week. Bye, everybody.